Hi guys, it's Kathy. I hope you're doing well. So don't encourage him when he comes in here. He'll come in here more. Um, I promised yesterday that I would play a attorney disciplinary hearing today. And I got one that just happened. It's very recent. Um, it's a little sad though. It's gonna be heavy today for a bit. But it's okay because once it's over, Fozzie had something that is going to bring it right back up again. So it's heavy for a bit. I just want to let you know when they say stepchild, they do not mean child. It was a fully grown adult. Not that that makes a difference. I mean, I guess it does make a difference, but only a tiny bit. Just so you know, there's no children in this video. None. But yeah, I promised a disciplinary hearing and we're going to get one. Oh my gosh, Victoria's up so early. What happened? Did Michael wake you up? Don't blame it on your kids. Did Michael wake you up? Victoria, wake up. Are you awake? Victoria, are you awake? Victoria, can you get me a cup of water? I just imagine she would want to pour the water on him, but that's her bed. So that's a tough one. I accidentally took a 4-hour nap. Oh, I love and hate that totally. I want a 4-hour nap. I want a 2-hour nap. Okay, I didn't share my screen. Let's get into this. It's only like an hour long. Don't talk to her. She deserves better than you talking to her. Victoria, Victoria, I'm very sorry.
This is a compulsory discipline matter that is predicated upon a judgment order for adjudication against the respondent, in this case, James Mayer Harris, and cause number CR 02235, State of Texas versus James Mayer Harris Jr. under the 424th Judicial District Court of Blanco County, Texas. The charge to which Mr. Harris pled guilty is under the statute, the Texas Penal Code 22.02B1. The elements of the crime that Mr. Harris pled guilty to: the intentional aggravated assault of a family member, in this case a stepson, with a deadly weapon, in this case a firearm. I'd like to go through the documents that we have to offer into evidence and exhibits that will establish our burden of proof for compulsory disciplinary, for the imposition of compulsory discipline, and then briefly discuss the arguments that have been presented in our briefing. The first piece of evidence is a certified copy of the information in the underlying case as Exhibit 1. The second exhibit is the order of deferred adjudication. In that case, a certified copy is also attached to the order of deferred adjudication on the terms and conditions of Mr. Harris's probation. The third exhibit is my affidavit attesting that Mr. Harris is the individual.
Can you hear it now?
Who pled guilty to the crime for which we're here today. The fourth is an affidavit of Blake Hawthorne attesting that Mr. Harris is an attorney licensed in Texas. Exhibit 5 is a waiver of indictment. The underlying case who pled guilty to the crime for which we're here today. The fourth is an affidavit of Blake Hawthorne attesting that Mr. Harris is an attorney licensed in Texas. Exhibit 5 is a waiver of indictment.
This is right from YouTube. So you can't hear. Okay, I'm just going to play it now. Can you hear it better now that I refresh? Hi, Carmen. Oh, no.
I would also like the board to consider Exhibit 6.
It's not muted. Okay, fine. We're going to change things up a bit.
Disclosure privileged information without your knowledge.
Can you hear that?
You attempt to object to
Gilgamesh. I love Gilgamesh. Where's Gilgamesh? Oh, are you one of Anthony's, Gilgamesh?
You feel you were given a fair opportunity to defend yourself and present your case in the Louisiana disciplinary.
Can you hear it, guys?
Do you feel that you were given a fair opportunity to defend yourself and present your case in the Louisiana disciplinary matter?
All right.
Mom was like, "Are you one of Anthony's?" Yep.
I hate this. So it's very hard when he's doing that. Okay. I'm going to press play. Okay. Just make sure your volume's not the whole way up. I think I know exactly what the problem is. Get ready. All right. Hold on. It's low right now.
Tax representation where you
Is that better?
fraudulent or criminal activity. did you seek to obtain
Thank
either
you.
of their legal services for the purposes of committing or furthering a crime or fraud? After you discovered that
Can you
your
hear
attorneys
it?
disclosed your privileged information without your knowledge or consent, did you attempt to object to the ODC's use of their testimony?
No.
And what was the ODC's response?
What are the cheap seats? What's that mean? What does that mean? The cheap seats are allowed today? What does that mean?
All right, I'm going to put on one we already played.
What does that mean?
Oh, no, it's too far back.
Dude, what? What?
There.
Is that like
I need to know if it's all the videos or if it's something wrong with me. There.
2457
Can you hear
Carolyn
that?
Barnes.
So this, okay. So apparently I can't play any of the newer videos on this site. On this, I don't know what they did to their audio. All right, we're looking. That's part 2. Wow. Part 1, part 2, part 3 for this attorney. Oh, look at all that paper. This was 11 years ago. I'm going to have to check that one out. How about Eric Paul Gifford? Does he sound good, guys? I'm going with yes. This was 11 years ago, so pre-COVID and everything. Let's see what Eric Paul Gifford did. This is good because the one that I had, which was real recent, it was a little sad.
Wait, when did I get res? I thought you didn't have it. You lied to me.
Proceed.
Judith Barrett for the Commission for Lawyer Discipline. As a preliminary matter, we had submitted objections to the exhibits that Mr. Gifford attached to his answer, as well as to some of the hearsay statements in his answer, and would like to know if you've ruled on those.
Since this is a hearing, they've been not offered as evidence. If they're offered, then you
This lady's like internal affairs. Like, you know how police officers feel about internal affairs? All attorneys must feel a certain way about her prosecuting attorneys all day, every day.
can reassert those objections. But, this isn't a motion. So, if they're offered, then we'll rule on the objections at that time.
Okay. This is a reciprocal disciplinary action brought pursuant to Part 9 of the Texas Rules of Disciplinary Conduct based on discipline imposed upon Eric Paul Gifford in the state of Florida for misconduct and where he was disbarred. The petition for reciprocal discipline was filed with the board on September the 6th, 2012, and an order to show cause was issued by the board on September the 7th. We're requiring the respondent to show cause within 30 days why identical discipline should not be imposed in Texas. The original proof of service was filed with board on October the 9th, 2012. On June the 16th, 2011, a complaint was filed in the Supreme Court of Florida in the matter styled the Florida Bar Complainant versus Eric P. Gifford Respondent, cause number SC 111182, TFB file number 2011 3122005A. On or about September.
Yeah, I just played a couple, I don't know how many days ago. Chat will say when I'm wrong. Like a week ago, this Barnes attorney that got up and was like really loud and obnoxious to the panel, real rude, super rude. She was the attorney there. Hi, Nan.
For the 12th, 2011, a report of referee was filed with the Supreme Court of Florida in the same matter. On February 20th, 2012, an order was filed with the Supreme Court of Florida in the matter styled Florida Bar Complainant versus Eric P. Gifford that states in pertinent part as follows. The uncontested report of the referee is approved and respondent is disbarred. The report of the referee found that the respondent admitted that he committed an act that was unlawful and contrary to the honesty of justice, failed to comply with the bar rules, Florida bar rules regarding trust accounts, committed a criminal act that reflected adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer, engaged in conduct involving dishonesty, fraud, deceit, or misrepresentation, failed to comply with trust accounting requirements, failed to hold in trust separate from his own property, funds and property of clients or third person that were in his possession, and failed to hold in trust, applying only to that purpose, money or property entrusted to him for a specific purpose. A finding of misconduct in another jurisdiction is conclusive for the purpose of this disciplinary proceeding. Under 9.03, the discipline to be imposed in this reciprocal proceeding shall be identical to the extent possible to that imposed in Florida, unless the respondent can prove by clear and convincing evidence one of the enumerated facts or defenses in 9.04. In his answer, he claims that the misconduct that was imposed in Florida warrants a substantially different discipline in Texas, and that his disbarment in Texas would result in a grave injustice. He cannot meet the burden for either of those defenses. Where Mr. Gifford stole money from a mentally retarded individual who was also legally blind, and, as in Texas, the referee in Florida considered the testimony and credibility of witnesses and weighed both aggravating and mitigating factors in making the recommendations in their report. Further, Mr. Gifford had an opportunity to contest that report to the Supreme Court of Florida before they entered the order disbarring him, and he did not do so. The disciplinary system is charged with the responsibility to protect the public and uphold the integrity of our profession. At the end of this hearing, the Commission will request that this board enter an order imposing identical discipline to that Florida imposed on Mr. Gifford and disbar him. Thank you.
Mr. Berry, can I ask you something before you get too far away?
Certainly.
Mr. Gifford, I'll give you a heads up. I'm going to be interested in your response to what I'm about to ask her also when it's your turn. My question is, are we certain that disbarment is the identical discipline? And I'll tell you why I ask. In the Supreme Court order, it does say respondent is disbarred, absolutely.
Yes.
But it says the uncontested report of the referee is approved and respondent is disbarred. And then you go over to the
I'll check
referee
it out.
report and it says disbarment for 5 years, the minimum amount of time authorized by the rules. And so I'm wondering, in the way we use the word in Texas, has he really been disbarred or has he only been suspended for 5 years as we would use the term?
He has been disbarred. In order to be reinstated, he does have to reapply and take the bar exam.
So it'd be analogous to our situation where you can reapply after
5 years, correct. They also have a provision where they can disbar without the possibility of reinstatement. So that's, I think, why they make that distinction, and he can probably speak to that, but that's my understanding.
So your view is disbarment, as we use the term, is the identical discipline, and as with any disbarment, he can come back in after 5 years and seek reinstatement.
Absolutely.
Any other questions right now?
Okay.
So, how do you get disbarred forever? I bet, Victoria, if you help me study, me and you can both pass the bar. Wait a second. Aren't you working towards that? Aren't you like taking steps to become a lawyer? How far did you get? Oh God.
I'll do that in my case in chief. That was just.
Mr. Gifford?
Thank you. And just by way of question, I'm not familiar with procedures. Is this opening statement or?
On these, we're pretty lax. If y'all want to do opening statements, go ahead.
Well, I just was curious.
Yeah.
I mean, I was prepared to put a case in chief on and then make argument. There was a combination of that here, and I just want to make sure I don't waste the board's time. I said when I indicated it'd be 15 minutes.
Yeah, if you want to make an opening statement, that's fine. If you just want to cut to the chase.
I think that would be in everyone's best
Yeah.
interest.
I don't think
I'm not here to take an inordinate amount of time.
Okay.
But let me go do that. If it's okay with the bar council, I'll put on my case, and then if we're making an argument afterwards, like.
Well, I think if you
I need to put on my.
yeah, she needs to put on
Okay.
her case first.
I'll defer then. and-
So go ahead.
Okay. Then I'll go ahead and make an opening statement.
Now, just a point of clarification, we've read the pleadings and I think we understand the positions of the parties and the rules, so I don't think there's any harm. Just cut to the chase.
Okay. At this time, I'd like to offer petitioners exhibit. May I approach?
Yes.
Exhibit number 1 is a certified copy of the complaint filed in the Supreme Court of Florida in the matter of Style Florida Bar. Complainant versus Eric P. Gifford, respondent, case number SC 111182, TFB file number 2011 3122005A. Exhibit number 2 is a certified copy of the report of the referee filed in the Supreme Court of Florida in the matter. And exhibit number 3 is a certified copy of the order filed in the Supreme Court of Florida. And exhibit number 4 is the original certificate of Blake Hawthorne, clerk of the Supreme Court, dated September the 28th, 2012, that shows that the respondent is licensed and authorized to practice law in the state of Texas. We seek disbarment as reciprocal discipline. And at this time,
I love that in chat it started out with me not being able to pass the bar, and then everybody got on Fozzie for that.
we'll waive our argument until,
Any objections to exhibits 1 through 4?
No, I reviewed the exhibits. I have no objections.
Okay, 1 through 4 are admitted.
thank you.
Mr. Berry is rested. Go ahead and put on your
Yes, thank you.
case, Mr. Hubbard.
Mr. Chairman, member of the board. My name is Eric Gifford. I represent myself pro se in this matter. As Mr. Berry indicated, I previously submitted an answer, and I apologize for the format. I was not exactly sure of the procedures. I have admitted to all of the allegations in the petition brought by the State Bar. The only thing I think I asked an opportunity to have was to come here and to be here present and in person. I feel like my actions require me to follow through all the consequences, including standing here before you, so that I at least get to meet you face to face, stand in this building, which I've never had the opportunity to do so. It is with great regret that I'm here under these circumstances. With that, though, I did promise to be brief, and I will. I understand the challenge that I face, and I really just wanted an opportunity to be able to present to you who I am in the small amount of time that I have. I've offered, along with my answer, a number of exhibits, and I acknowledge the motion by the bar. I'm asking to admit exhibits 2, 3, 4, 7 of those exhibits into evidence absent objection by the counsel for the bar. And those are in the index. One is an affidavit. Second is a letter from me to my law firm, former law firm. The fourth is a resume prepared by me during the Florida bar proceedings. And the last exhibit, 7, is a composite exhibit listing a number of military awards that I received from 1991 through 2002.
And we would object to those exhibits.
Are your objections the same as contained in your filed pleading?
They are.
Overrule the objections and admit the evidence.
Thank you. And I'll also ask, attached to my binder were exhibits 10 and 11 and 14. Those are copies of cases both in Florida and Texas. I'm not offering those into evidence, but I provided those to the board. I'm asking basically, if necessary, you take judicial notice under Rule 201 so that you have those available to you. That's the basis I was intending to offer them, not as evidence in the case in chief. I hope you understand that. I didn't know that the counsel for the bar had objection to that.
That's fine.
Okay, thank you. With that, again, it is under very difficult circumstances that I'm here. I do admit to the conduct as charged. I did so in the Florida bar proceedings to the extent that they challenged that. Once I committed the act which I was charged with, I cooperated in all respects possible, and I've continued to do so. The main reason I'm here today is merely to present and offer one point. And there's no surprise. I provided an argument in my answer. You pretty much can see that. I know counsel for the bar has already addressed that to some extent. But the evidence that I've provided shows a lifetime, a career of mine that I have devoted myself to reaching for high achievement. I've devoted it to service to the country, to other people. My resume provides a snapshot of that. And I'm not here to suggest, I know the case law doesn't provide that a record of past achievements somehow is an excuse for an act of misconduct or acts of misconduct. I know it is not. I offer that only to show to you and present to you that this action on my part was an aberration, is an aberration. It's not who I am. To this day, I cannot explain why I made the choice I made. I had other options. I was in a bad place, having divorced in 2008 after being married for almost 14 years. Did everything I could to preserve that, to take care of my children and balance the financial demands that were placed upon me, not only post-divorce with child support and the like, but with the devastation to the Florida economy as a result of the housing bubble. In my resume, you may see a large part of my practice was devoted to real estate and construction law. And clients that I had built up prior to making partner were now coming to me for advice on dealing with debtors, asking for bankruptcy advice, which I didn't practice. So they obviously had to go elsewhere. So all of that culminated in a perfect storm, if you will, in February and March of 2011. Coincidentally, I had begun taking antidepressant medication, Lexapro, in 2008.
I'm going to object to the extent that if he's going to testify, I think he needs to be sworn in.
Yeah, and here's where I think we're headed, and let me see if y'all agree. I believe that what your argument is or will be is that there's the similar discipline is going to work a grave misjustice, and possibly that the discipline would be different in the state of Texas. Okay. And if you are successful in either one of those, then that allows the board to impose some discipline. So I think we're going to need some information too, a little background perhaps, if we do find that you have carried your burden, something to help us come up with the appropriate orders that then comes within our jurisdiction. And that's going to also require some testimony. So I think it'd probably be better to offer that under oath and go ahead and offer your facts in that way. But also include okay, if we find you do carry your burden, then give us the background that's going to help us determine what an appropriate remedy is here.
I understand.
Okay. Why don't you go ahead and have the court reporter swear you in and continue offering your testimony.
From here is fine.
You just be sworn, you can stand there.
Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Thank you. And I won't rehash what I was just doing. I probably should have asked to be sworn in because that's what I intended to do.
Were your statements earlier now under oath, you adopt those statements?
I do adopt those, yes. And I believe where I left off was describing antidepressant medication, which I had been prescribed in 2008. This was just prior to
my divorce, which happened in March of that year. I continued on that medication without any interruptions, essentially through February of 2011. And it was at that time during a trip to Texas that I misplaced or lost my prescription bottle, and essentially discontinued abruptly the medication that I was on. As I think the referee pointed out, and I will certainly testify, I was not incoherent. I was not unable to function or to think. It was maybe more difficult, but I was certainly not unaware of actions and potential consequences. I think in looking back, I maybe didn't care as much. I was depressed. I believe I characterized what I did as professional suicide. And that's still how I see it. I felt trapped financially with a number of many things. And at that time, I didn't think or appreciate the consequences. I think of myself as a bright person. There were things I could have done had I had a devious plan to be more, I don't know, I guess I did it openly as if I wanted to get caught. I didn't hide anything. And I'm not saying that as a mitigation. I'm just still trying to grapple what I did and why. The point I'm trying to make to the board, as I mentioned in my answer, is this act on my part, which, to properly define it, I represented a client, I believe in 2003 or 2004, and Jerry Jackson, a young man who had been struck by an automobile in a pedestrian accident, broke both his legs. And I knew him through Adult Retarded Citizens of Marion County. I'd been a member on that board for quite some time. I say I knew him. I was a board member at that institution. And as a result of that, I was told that there was someone that was in need, Jerry Jackson. They needed some advice. They were looking for someone to assist him through the post-accident process. And I met with him and assisted him through the insurance issues and whatnot, and obtaining a settlement for him, which was placed into to our firm's trust account. And it remained there for some time, primarily because he was on Social Security disability. He needed a special needs trust set up, which I didn't do. I sought assistance from other attorneys in Marion County that did that type of work, and there were only two, neither of which I could obtain pro bono services. So I was trying to preserve those funds for him. And of course, the irony is, some years later, I was the one who obviously had access to those and made a terrible decision to utilize those funds for my personal purposes. The amount that was taken in March was $5,000. I used it for some child support, and also for tuition for my children. I was well behind on private school tuition, which I was required to pay as a result of my divorce, and I was trying to keep them in school. They were being threatened with being ejected, essentially, for lack of payment. I did, and I want you to know, I did repay that money as soon as possible, less than a month later. Once I liquidated my 401k, I paid that money back in full. And again, the point I'm trying to make to the board, and I will be brief, is that if you look through my resume, you look through my career, this was a single incident. You know, our counsel has listed the number of ways they charged it. It was me taking $5,000, a horrible violation of my client's trust, of the profession, and certainly not something I'm desperately not proud of. And I understand that disbarment is and was, and I respect that decision, which is why I did not challenge it in the Supreme Court. The reason I'm here today is mainly to present to you the only argument that I have, and that is, if you review the cases that I presented under Exhibit 10, they all involve instances where the referee and subsequently the Florida Supreme Court imposed a sanction of suspension of some period of time, with or without conditions. All those cases involved attorneys who had committed an act of misconduct, misappropriation in every case, involving one incident of misconduct. They had good records. They had mitigating evidence or testimony and evidence to support their case. And I believe and still believe today that my case more appropriately falls within those. On the other hand, the referee considered cases, there were 4 of them, which are listed under 14 of my exhibits, that involved cases of misconduct with misappropriation. But uniquely, in all of those cases, it involved instances of multiple acts of misappropriation, either several occasions or misappropriation over a period of years. And I'm not saying the amount matters, it's the number of times that it occurred. In all of those cases, Valentine Miller was from 2004 to 2006.
Kelly, I don't understand what you're saying, and I really want to. Can place up to $15,000 with being penalized without being penalized by the government. Who can and where can they place it? Like in a savings? What are you talking about? I need to know.
That attorney dipped into her trust account and used funds inappropriately, long period of time. Brownstein is the other case from 2007. That individual was charged and brought before the court for misappropriating funds in excess of $20,000 on an instant. But during that proceeding, he testified that he had done so numerous times before, both in the 1990s and again in 2000 to 2004. In the last case, Travis also involved an audit which showed between the years of 1996 and 1997, an attorney had used funds in excess of $35,000 of the client's money. I am not in any way saying that what I did pales in comparison. Taking clients' money is the worst thing that can be done. I recognize that. I did it once. I will never do it again. I did it at a time, coincidentally, when I had gone off medication, which is not advised, resulted in lack of clear thinking. And as a result of that, I had asked that at least that be brought into consideration. Texas has also, this board has also, in the case of, I believe it's Brown that I provided, awarded sanctions in the form of suspension for misappropriation of funds. It's not unheard of. And I recognize the burden I carry is quite high. Clear and convincing evidence. I've practiced appellate law. I know what that is. That's a virtual, I'm wasting my time. But I'm not wasting my time. I'm here because I need to be here. I need to see this through. And I respect whatever decision you reach, and I understand the mountain that I have to struggle through to prove that what happened in Florida somehow is a grave injustice. I did not find any definition of that, but the term alone, grave, is very serious and very significant. Or that Texas would not impose similar punishment. There are plenty of cases where misappropriation of funds would result in that. I only ask that you consider what I've done, consider the results of the Florida bar case, and consider whether or not I have anything to offer short term. I'm really just trying to give you a reason, even a small one, to give me a second chance. That's all. That's why I'm here. Like many that face these disciplinary proceedings, I consider it very, very strongly not even coming. It's very intimidating. It's very difficult to be here and face my mistakes. But I have offered and proposed a sanction which I believe would be good for me and would allow me to help those. That's really why I wanted to practice law, was to serve others. The best job I had, and I'll say this to anybody, the best job I had was doing legal assistance in the military for a full year. I went in that job thinking I was being put out to pasture because I was being strong-armed into deploying overseas, which was something I didn't want to do for reasons that don't matter. But I ended up helping people. They were at the door all day. I loved that work. I would like to do that again, which is why I've proposed and asked for the opportunity to do that. I'm not sure the board has ever done it. I'm not sure that you would even consider it. There may be reasons not to, but I have suggested.
Do you know how I know I can wear all my glasses at the same time? Because there are many times where I'm looking for my glasses and they're up on my head. So I find another pair and I have like glasses, and then I reach up and I'm like, oh, there's my glasses. Found my glasses. He came from under the green screen. That's exactly what he did. That's my son. I yep.
A suspension for whatever period of time you deem appropriate. And I would welcome the opportunity to try to restore to our profession what I've taken away, to help those in need, like Jerry Jackson, through pro bono service. I picked 300 hours a year. I suggested that, and it's a somewhat arbitrary number, but that's 8 hours every Saturday for a year, roughly. That's how I came up with it. And I said 2 years. I'll do 3. I'll do 5. I just want a chance to prove myself. And again, I'm not asking for an opportunity to practice law for profit. I don't want that. I will make do and I will make it work. I have not represented clients for profit since coming here, and I don't intend to do it again. And I welcome the opportunity, like I said, to do pro bono. There are opportunities for me, and there's definitely a need in this economy. And that's all I'm asking. I'm not sure that you feel able to do that, but I respect your decision. I thank you for your time. And if there are any questions, I'll be happy to answer this.
Why don't we do this? Why don't you go ahead and take the witness chair and allow
Yes,
Ms. Berry
certainly.
to cross-examine you on anything she might have. Then I'm sure we'll have some questions for you.
I do.
Go ahead, Mr. Berry.
Mr. Gifford, I believe you testified that you didn't hide anything. Is that correct?
I may have used those terms, yes.
And yet didn't you tell your law partner, and I think this is in the affidavit that the board admitted, that when they first confronted you with this, you told them that the checks had been deposited into bank accounts. Isn't that correct?
That's his favorite dinner.
I have to look at the affidavit. I will say the checks, there were 2 checks written, and yes, one of those was deposited in I believe it was a money market account, and the second check was negotiated to me.
Okay, may I approach?
Yes.
You please read number 5.
Yes. Says this is affidavit from Mr. Gilligan, quote, "My partners and I were uncomfortable with the transaction because we did not believe it was appropriate to have placed client funds into an account in the name of a firm member. Thus, we continued." I'm sorry, I read the wrong one. Number 5, on March 30th, 2011, Mr. King and I briefly discussed the transaction with Mr. Gifford, who had indicated that all the proceeds of the checks had been deposited into an account for the benefit of the client.
That wasn't true, was it? You hadn't deposited.
No, I had negotiated $5,000, the check for $5,000 to myself. That was the misappropriation.
Okay. Now, the individual, Mr. Jackson, was retarded, is that correct?
He had an IQ, I believe, of 90. He was independent, living alone. He had a social worker. So when you use the term retarded, there's all different spectrums of that in terms of an individual's capability. And again, his IQ was 90. He lived independently with the assistance of a social worker or caseworker, if you will.
Okay, so he had a mental handicap. Though.
Yes, he did.
And he was also legally blind.
He was not legally blind. Well, after the accident, yes.
Okay. So at the time that you signed him up as a client, he was legally blind, correct?
He had suffered an injury to his eye, yes. So I don't believe he had been determined at that time what his vision impairment was, but
And he did not call you, did he?
he did not.
Okay.
No.
You testified that you tried to find someone to create the documents on a pro bono basis, on a special needs trust or guardianship or whatever is the appropriate mechanism for that in Florida.
Yes,
You didn't represent him on a pro bono basis, did you?
I did not. No,
In fact, your fee was close to $16,000 on this,
it was.
approximately?
Well, yes, it was a third of the total recovery.
Mhm. And would you agree that you probably could have gotten a special needs trust done for under $2,000?
Yes, with the right attorney, sure.
Okay. And yet you took more than that, correct?
The misappropriation was $5,000. Yes.
$5,000, okay. And I believe, at the time you took the money, you had already remarried, is that correct?
Yes.
Okay, so and how long were you off the medication?
The trip to Texas was in the latter part of February, probably the 20th, I believe. And coincidentally, it was a trip to, my then wife was from Texas. I was coming here to help her move to Florida. So it was probably about 3 weeks by the time the misappropriation happened.
Okay. And none of your law partners, you continued to work?
During that time?
Yes.
Yes.
And no one noticed any problems with your functioning at work?
Are you asking me to speculate? Did they,
Oh,
no
I
one,
mean,
no one
the-
approached me.
I mean, the
There were
referee-
people, you're asking me, there were people that noticed.
The referee's report stated, I believe, that no one in your law firm or whoever testified for you at that trial from your law firm had noticed there were any problems with your work during that time period. Would that be a fair statement?
No, well, yes, and it wouldn't surprise me. I was a partner, nobody supervised my work.
And you didn't report any problems to the physician when you saw him to get your prescription refilled either, did you?
I went to him to get the prescription refilled.
Correct.
And the reason to refill it was because of the problems I was having. It's inappropriate to say no one testified there were problems. My ex-wife testified at the hearing and said that I was more argumentative, more difficult.
I'm going to object to hearsay on that.
You had already asked him if anybody had testified as to noticing, so I'm going to let him go ahead and
I
answer.
believe I asked him about his law partner, but,
I'm going to overrule objection.
okay. In fact, isn't it true that the only thing that you reported to the doctor as a result of not taking your medication was some irritability?
I believe that's what his report said, yes.
And
Fozzie is
are
very
you trying to
sensitive.
tell the board
I saw him unbutton
that-
his shirt slowly once.
you took the client funds because you were off your medication?
No,
Okay. Is that, you're not trying to blame this on not taking your medication?
absolutely not.
The funds that were deposited into your firm's trust account during the, what, approximately 6 years from the time the case settled
I
and
believe
so
so.
they earned no interest for your client, did they?
They did not.
And you didn't volunteer or reimburse the client for any interest that those funds could have
I have
earned
not,
during
no.
that period of time, did you?
No,
And your firm actually repaid the amount.
There goes Maiko, fighting hard to get me what I really, really, really need.
To the client
Thank you,
originally,
Michael,
is that
thank
correct?
you.
The firm restored the funds to the trust account, I believe on April 2nd, 3rd, or 4th, immediately after finding out what had happened. And then I repaid the firm, I believe as indicated in the exhibit, on April 27th, which was,
That was after the bar's investigation had been begun?
it was after my law firm followed their responsibilities by reporting my misconduct. So to that extent, the bar had been notified.
It was also after they had taken your deposition, is that correct?
That I don't recall. I'm not sure the dates. If that's true, I just know I repaid it as soon as I had, immediately after I got the funds from my 401k.
See, your deposition was taken, I believe, on April the 12th of 2011.
Okay, then yes, it was several weeks after the deposition had been taken.
Okay.
Again, as soon as I had the funds available, I liquidated my 401k so that I could pay that money, and I immediately paid it right after that.
Was there a reason you couldn't liquidate your 401k or get the funds out of that prior to that time?
I had submitted the necessary paperwork through my office, and it was as soon as the check came. I'm not sure why it was delayed, but I immediately asked for those funds, and it took.
When you say immediately, when did you submit the paperwork?
Well, I was terminated on April 1st, and I believe within the next week I requested the funds. Our, what do you call it? 401k manager was in Jacksonville, and well, that's the time frame.
Now pass the witness.
Why don't you go ahead and retake the lectern so we can, it's kind of hard to see the witness.
I understand.
And I'll give you questions. Ray, you look like you're about to.
Well, I was wondering, Mr. Berry, whose affidavit were you questioning him from, please?
That's the affidavit of one of his law partners that was you all admitted is, I think, Exhibit 2, or I don't know what
Poor
number
guy.
you all gave it. It was
Aw.
one, I think he had designated as Exhibit 2, Patrick G. Gilligan.
Thank you.
Any questions
Wow, what are you wearing?
for the witness? Let me ask you this. You took a third of the total recovery as a fee, correct?
Yes, approximately.
After that time, were there any other charges against that for work that you did?
There was a $500 charge. One of the associates in the firm had prepared pleadings for the Special Needs Trust. And I believe that $500 had been charged out of the account. There were other charges, but they weren't firm related. During the 6-year period of time, Mr. Jackson had requested funds for furniture. He had moved into an apartment with a roommate, so they needed furniture, and that happened, I think, probably 3 occasions. But those were disbursements made directly to him that my legal assistant took care of. And then the $500, I believe, was also reinstated or reimbursed by the law firm, by Gilligan King Gooding.
When was the charge for the paperwork for special needs
All you men have no idea how close you are to getting banned. All of ya.
trust? When was that work done?
I honestly don't recall
In
the year.
proximity to the time that you took the money out,
It
I mean,
was-
it a year before, 2 years?
It was probably a year before. The money had been in the trust account way too long. And part of the reason, well, the interest in getting the money out of there was to get it to gain interest. And obviously that presented an opportunity that I took advantage of. But it was about a year before my associate, or one of the associates in the firm, I asked him to look into it, try and prepare pleadings so we could try and do that work.
Why wasn't that completed?
The paperwork was not in a form that was very well,
Not
it's really
time.
usable.
Not
I mean,
time.
it's maybe a very easy process. I'm sure it is. It's not an area of law that I practice in, and our associate, no one at our firm did as well. So it was work that needed to be redone totally, and it just never got done.
Okay. Tell me a little bit about the Florida system. Is there a presumption in Florida of disbarment under the standards?
There is for certain acts of misconduct, there is a presumption.
Okay.
One of those being misappropriation.
And I'm really asking you to kind of help us understand
Yeah,
the
sure.
differences between Florida and Texas.
There is a presumption of disbarment for misappropriation. However, any of those cases I presented to you will acknowledge, and the Florida Supreme Court has acknowledged that presumption may be overcome by mitigating evidence, such as what I presented to the Florida bar and to the referee, and what was presented in all those cases that I cited to you. Mitigating evidence is a long list of things that can be presented, past record, reimbursement, remorse, any number of things. And in fact, that presumption has been or was overcome in a number of cases. And I had hoped that would be the case in my instance. The difficulty I think that I had is we presented written arguments to the referee. Much like I did here, I presented all the cases that I was to rely on. I did not get a chance to rebut or respond to the cases submitted by the counsel for the Florida bar. And obviously, I could have done so at a higher level at this Florida Supreme Court, but I respect the decision, and the challenge there is much like it is here. It's very difficult to overcome a deference to a referee's report, and I recognize that.
So in the Florida grievance system, you don't have a hearing, you just submit written documentation?
No, I'm sorry. There was a hearing. The hearing was a lengthy one, and at the end of the day, the district court judge, who was acting as a referee, rather than listening to argument after the presentation of evidence, and keep in mind, it wasn't a hearing to determine guilt or innocence. I'd acknowledged my role and pled guilty. The sole purpose of that hearing before the referee was to determine the appropriate sanction. And at the end of that, she just said, submit written arguments within 5 or 10 days, which we both did. And then she made a decision based on that, and basically signed the report, proposed order that was submitted by the Florida bar.
Okay. Help us a little bit with why you believe that identical discipline would work a grave injustice.
Well, again, as I mentioned in my comments earlier, I did not find in Texas case law, there may be some definition of what a grave injustice is. I suppose I could have looked at statutory construction and something like that to find out how that is defined. Obviously, from a personal perspective, it would be very easy for me to say it's a grave injustice, but I think that's a bit shallow. The main reason and the only argument I have is what I've made, is that the weight of Florida case law suggests that perhaps I should have had a lesser punishment. And not because I deserved it, just because my record of achievement, my record of service for 44 years I'm not perfect, but it was certainly unblemished. I never had a disciplinary action taken against me. I never had a complaint that it wasn't resolved or even addressed with a client, never got to that level. And I had a lot that I had accomplished and a lot of mitigating evidence. One of those, again, as I testify here, I don't propose to tell you that the medication made me do it. It didn't. My mental state, the circumstances led to me not making a decision that I knew was wrong. If I could take it back, I would. I can't. And is that a grave injustice? I don't know. I can't pull a case out and tell you, look at this. I wish I could. I'm just here as a person. I'm very sorry for what I did,
Fletcher.
not just to my client, to the
Fletcher.
people that trusted me, to the family.
Epic.
I mean, it goes, actions have a ripple effect, and this one has been very significant. That's a sympathy argument, I know. Legal arguments, I don't know that I have one. I'll be honest with you, I'm not here to argue. I'm not here to make this a long, drawn-out process. I'm just here because I feel like I need to be here, whether it's for closure or, again, just to ask for a chance. That's it.
One of the other things that we are tasked to look at is determine whether the misconduct established in Florida, which would be you're taking your client's money, warrants a substantially different discipline in Texas.
Right.
Is it your contention that in Texas, if you take your client's money, that you get a substantially different discipline?
No, it's not. I mean, I think misappropriation in most cases, most courts, most states have held that's the worst thing a lawyer can do. It makes sense.
We're waiting. Come on.
There are certainly other offenses that lawyers commit, but I guess that one is more egregious because it affects the client and the profession, but the client, violates client trust. I do know, as I mentioned with the case that I presented, is that it appears that Texas case law does acknowledge that in the appropriate circumstances, these disciplinary cases, from what I understand, are case by case basis.
A little more.
And as with the case Brown that I presented to you, that gentleman misappropriated a substantial amount of money. I believe it was all repaid, and he was suspended for a period of time. So it is not my understanding that disbarment is mandatory. It is perhaps presumed to be appropriate and should be, but in appropriate cases, on a case basis, suspension has been awarded.
Anybody have any other questions or things for Mr. Gifford? Mr. Berry, any further questions for the witness?
I don't, Your Honor.
Okay.
Thank you.
Do y'all want to make a brief close or leave it at that?
I do.
Okay.
Disbarment is an appropriate sanction for an attorney who steals their client's money. In this case, the referee
I almost tripled that yesterday. Oh, yeah.
considered both mitigating and aggravating factors that were present in the case. Emotional problems and claimed depression as a result of a divorce. But the referee found that he'd already remarried, and that indicated to the referee that he'd moved on with his life. The psychiatrist testified.
Junkins Murph, were you here from the beginning? Because at the beginning I had a clip ready and then no one could hear it. So I found a different clip real quick on the fly and no one could hear it. So then I just started playing a random clip from 11 years ago. So I have no idea what happens at the end. None. I was sort of hoping like the other girl, other people would Google Eric Paul Gifford because that's what they did the last time and they just haven't yet. We only have 3 minutes to go.
Contrary to the internet research that Mr. Gifford had done, that there was no causal connection between not taking the meds and the misconduct. Aggravating factors that are compelling in this case are particularly the vulnerability of the client. The fact that the client was mentally handicapped, was legally blind. There was also indication in the report that the client had never contacted Mr. Gifford. He went and signed the client up within 30 days of the accident. He took his fee. He took a full 1/3 fee from this client. And there was also some indication that he had indicated to the brother that he was going to do this pro bono. He did not. And yet, when it came time for a special needs trust, he never got it created for 6 years because he couldn't get that done pro bono. Out of his 16,000 fee, it would not have taken that much to even pay for it himself, if that was his true concern, was maintaining funds for the client. As a legal profession, we're very fortunate that we have the ability to police our own. But we have a duty to maintain respect for the legal profession. And it's a serious matter when an attorney intentionally misapplies, misappropriates, steals client funds. It's a privilege to be a lawyer. It's a privilege most of us have worked very hard to get. It's a privilege most of us work very hard to keep. When an attorney violates the rules, especially takes client funds, it's a privilege they don't deserve to keep. Respectfully request that this board enter a judgment disbarring Mr. Gifford. Thank you.
Mr. Gifford?
I just want to thank you all for your time and attention. I know it took longer than expected, but I respect the job you're doing, and thank you for your time.
Thank you. Appreciate your appearing before us. I know it's not an easy thing, and we.
Okay, so here's what I got. So in 2012, he was in fact permanently disbarred. However, remember what they said. People permanently disbarred every 5 years can reapply. So I know this is 2018, and I think this is the magazine Victoria was talking about. So in 2018, this is under reinstatements. So, and that's the same case number. I looked it up. 51 years old, filed a petition with the 416th District Court for reinstatement. I don't know if he was reinstated. I don't see an answer right now. But he applied in 2018, so he could. He could be practicing right now. Who knows? We don't know. So don't anybody use him if you have, funds that you don't want misappropriated. Hi, Broken Tile. Okay. Now it's time. We didn't do Judge Fleischer yesterday. So the last time Judge Fleischer wore this jacket right here, I made this background from his jacket. So, of course, I have to use this background today. But before we do that, before we go into Judge Fleischer, I need a break. I need to take a break. I have to. So I'm going to let Fozzie take over while I take a break. Be good while I'm gone, okay? Okay, you can barely hear me. Alright, I'm going to bump up my microphone a little bit. It always scares me when I do this because I blow out people's eardrums. Is that better? Who said that? Does this sound a little better? Alright. It doesn't matter. I'm taking a break. A tiny bit more. Absolutely. Give him an inch. They want a mile. There we go. Is that better? Alright. There we go.
Hello, everybody. My name is Fozzie. Welcome to Fozzie Vibes. It's kind of like court vibes. I do like to giggle, but these don't jiggle. She's going to kill me for that one later. Just wanted to, I asked Kathy if I could spend a little time with y'all and give her a break so she can get up and stretch her legs. Hey, Kathy, do you mind getting me a beer while you're up? Don't you dare open it either. Anyway, she hadn't signed off on me being allowed to do any court cases yet, but I did find a clip out of court. It's Judge DeSantos out of Wyandotte, Michigan. And it's not really has to do anything with the case she's got going on. It's just a quick clip. I thought it was pretty funny. You're going to see somebody doing something wrong on the screen, and I'm going to let it play for about 5 seconds and then stop it and talk about it a little bit. But Judge DeSantos, she's up in the top right-hand corner and then the middle lower corner. But watch the top right-hand corner whenever she looks up at the screen at a monitor to her left, and she notices it.
That amount, 0.149, which is the blood test, cannot be contested. You believe it's inaccurate?
All right. You see anybody do anything wrong? Oh, yeah. Watch Judge DeSantos in the top right-hand corner.
Reflection of where you were at the time. You were stopped immediately after when the blood was drawn.
Yes.
And then you were taken to the police station and incarcerated. You believe that you were taken into custody because of the consumption of alcohol affecting your ability to.
Now she stopped and she's looking at her. She's looking at her little laptop over here to see if she's really seeing what she's doing. That attorney in the middle is driving. That car is moving while he's in court. Pretty funny.
Drive and you were visibly impaired.
Correct.
I have another question.
All right, the court does find that he is knowing, voluntary, and factually accurate. The court will accept your plea per the plea agreement. And I'm going to interrupt for just 1 moment. Attorney Torres, Peter Torres, if you're driving, we're disconnecting you from the Zoom, sir, until you're not driving any longer.
No problem. I'm parking right now.
You have to be zooming into the court while you're driving.
Not a problem, Your Honor. Thank you. I don't know if he turned it off or if the court staff did, but I thought that was pretty funny. You just don't see an attorney do that very often. Oh, here she comes. Oh, thank you. Never let Kathy get you a beer, especially if she's going to open it. Anyway, that's all I had. I appreciate y'all letting me into your stream today. Thank you, Kathy. Take care, everybody. Bye, CJ. I got a little outro that I'm going to play for y'all. It's I ripped it off from Kathy, but I made it my own. Ozzy likes to drink beer.
Look at you go. I told him to find court clips, and this is what he did. Good job, Fozzie. Good job. That was supposed to lift us up after the bad court case, but we didn't get to the bad court case. But CJ looked it up. So the lawyer we just went through, he did in fact get permanently disbarred and then reinstated. So he is a practicing lawyer in Texas right now. Yep. Oh, I'm too far. Gooch. We didn't see Fleischer at all yesterday, which was rough, guys. But you guys saw him in his stream. But he doesn't have a stream today, so.
All right. We have Mr. Morales on page 12. Morales.
Can we just leave here? Can we just leave here?
Fozzie or the lawyer? Who are we talking about?
We just left and now we're back. You are Juan Morales Calel.
Yes.
So you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. So you are facing a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir.
Anyhow.
Morning. On December 1st, 2024, at approximately 12:11 a.m., the officer conducted a traffic stop on the defendant's vehicle after observing it fail to maintain a single lane as it drove from the second to the fourth lane without using a turn signal, nearly striking the officer's marked vehicle. The vehicle continued to drive outside of the marked lane as it drove north on Hillcroft Avenue, and upon contact with the defendant, who was in the driver's seat of the vehicle, the officer detected an odor of an alcoholic beverage, glossy eyes, and slurred speech. The defendant admitted to drinking prior to driving, and standard field sobriety tests were attempted. However, officers were unable to observe HGN because the defendant was unable to follow instructions. Walk and turn, 5 out of 8 clues were found, and one leg stand, 3 out of 4 clues were found. The DIC was read, and the defendant consented to breath. The results were .191, .188.
Okay. Any prior DPIs?
No, Your Honor.
Have you run it?
There's no driver's license on record, Your Honor.
It's got to run something. If you can run an NCIC, an FBI number, just let's make sure he doesn't have any prior DWIs. Just because it says a DWI first doesn't mean anything.
Yes, sir, we run that, and there's no prior,
Okay.
there's no driver's license.
Mr. Morales, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Are you a United States citizen?
It's not an echo. It's the translator. It's Luis.
So the answer? No,
Are you in this country with or without permission?
without permission.
What happens if you go to jail, Ms. Morales?
I don't have any idea, I don't know.
Are you in this country with or without permission?
Sin permiso. I'm without permission.
So what happens if you go to jail?
Entonces, ¿qué le pasa a
I want you to think about
¿Qué
this.
piensa acerca de esto? Yes, you're right, I shouldn't be doing this here.
Immigration sweeps the jail on a daily basis, every couple of hours. If they find you in the jail, they will put a detainer on you and you will be stuck in custody until this case is over with and then shipped off to immigration. You will sit in jail for about 6 to 9 months, if not longer, waiting for all that to happen. If you do not want that to happen, then don't violate my laws, don't endanger my public, and follow my conditions. The first condition is you're not to drive. You don't have a Texas driver license, so you're not allowed to drive, and I'm making that a condition of your bond. You will be signing a promise with me today indicating that you're not going to drive, and I don't care what your deal is. I don't care what your excuse is. You cannot justify getting into a car for any reason. If you do, you will go to jail, and I can have a contempt hearing and hold you with another 180 days and a $500 fine every time you drive. Likewise, no dope, no illegal drugs, no alcohol, you will be randomly tested. You test positive for drugs or alcohol, likewise, you will go to jail. You have a lawyer. It is your responsibility to stay in touch with Mr. It says, I have Sharma.
That's it. It's the other Morales, it's Juan.
The top of it.
Oh, okay. You have a lawyer. It's your responsibility to stay in touch with counsel. If you lose out of contact, if he tells me that he can't get hold of you because you're playing games, likewise, I will issue warrant for your arrest. Mr. Morales, you will not get any more warnings. Heed this, take this as it is. If you don't, we have only one place for you.
Okay.
All right, we'll have you come up here, swear to us that you're not going to drive. We'll get you to Ramona to sign a receipt. You will get with Felicia for your bond conditions, and after that, you're free to go. Thank you. Are you ready for more Spanish?
Yes, I got 3 more Spanish ones. Mr. Costa, Jose Costa on 1. Costa.
Do we have multiple DWIs? Because I don't want to just go through the whole thing.
I didn't know.
Yeah, okay, so Acosta's first. Who's next?
Next one is Mesa on 11.
Jose Acosta, come up. Franco Mesa Garcia, come up.
And our next one is Yola on 19.
Okay, what the heck? So Victoria's not here for court. And then we finally get to court with Victoria here, and Victoria leaves. And now we are still Victoria-less. Ugh, it hurts, guys. Pain is real.
Carlos Ulloa Hernandez, come up.
Thank you, Snoopy. Thank you.
Gentlemen, I'm bringing all of you
She was in prison, but she's out now.
here now because I don't want to repeat myself 15 times. All of you stand charged with driving while intoxicated. All of you are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause on each of your cases. Each of you have the right to remain silent, the right to have an attorney present. If you cannot afford one, one will be appointed to you. Let's start with Mr. Acosta.
Sick of prison.
The officer initiated a traffic stop after observing the defendant drive without headlights at 8 p.m. Upon contact, the officer observed red glassy eyes and an odor of an alcoholic beverage. The officer called the Spanish speaker to assist, and in plain view on the passenger front seat, the officer observed an open and an empty bottle of alcohol. The defendant
Drinking while driving, is that what you're saying?
There was an open container, Your Honor. And the officer conducted standard field sobriety test. The HGN was unable to be completed due to the defendant's failure to follow instructions. The officer then transported the defendant to JPC, where DICs were read. The defendant consented to breath, with the results being 0.132 and 0.140.
What did you say the stop was for?
For driving without headlights at night.
Mr. Acosta, I'm going to find that there's probable cause to go forward with your case. All right, let's go with Mr. Mason.
Yes, Your Honor. On November 29, 2024, the officer was flagged down by a witness at Tomball Parkway. The officer observed the defendant's parked vehicle on the number 1 lane northbound feeder road with hazard lights on. Upon contact with the defendant, the officer observed the defendant to have red glassy eyes and a strong odor of an alcoholic beverage. The defendant admitted to drinking prior to driving. Standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 1 out of 8, and 1 leg stand 0 out of 4. The DIC was read and defendant consented to breath. The results were 0.093 and 0.089.
So he was by himself?
He was by himself, Your Honor. He was just stuck on, park. His vehicle was parked in northbound feeder road with hazard lights on.
Okay, I see it. All right, Mr. Mays, I'm going to find that there's probable cause to go forward with your case as well. Lastly, Mr. Ulloa.
Yes, Judge. On December 1st, 2024, officer conducted a traffic stop on the defendant's vehicle after observing it run a red light at an intersection. And upon contact, the defendant was observed to have a strong odor of an alcoholic beverage, red glassy eyes, slurred speech, and was stumbling. The defendant stated he was coming from a bar and admitted to drinking prior to driving. Standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 3 out of 8, 1 leg stand 3 out of 4. The DIC was read, but the defendant refused, and a search warrant was signed and executed.
Have you checked on all 3 to see whether they have other DWIs, prior DWIs?
Acosta has no priors, Mesa has no priors, and Ulloa also no prior DWIs.
Gentlemen, I don't know what your immigration status is, but if you are not in this country with permission and you go to jail and immigration finds you, they will put a detainer on you and you will be stuck like Chuck in custody until these cases are over with. And then you will be shipped off to immigration, or you will sit for another 6 to 9 months waiting for immigration to do whatever they're going to do. If you do not have a Texas driver license, you are not allowed to drive. Do you understand?
Yeah.
Are you this United States citizen? Are you in this country with or without permission, sir? What happens if you go to jail? What did I just tell you? Did you hear anything that I just said?
You're weird.
And how long will you sit in custody for that to happen?
9 meses.
Likewise, are you in this country with or without permission, sir?
Without permission.
Do you understand everything that we said? You as well. Are you here? Are you a United States citizen?
With permission.
What type of permission do you have?
I work.
I don't know whether you're lying to me or not. And Mr. Ulloa, it really doesn't matter. But I'm trying to warn you of the consequences of what happens if you go to jail. It really makes no difference to me whether you're this, whether that, I don't care. All I know, gentlemen, I want my streets safe. And if you don't have a Texas driver license, you're not allowed to drive. Each of you will be signing a promise with me that you're not going to drive. And I don't care what your reason is. If I find that you drive, and I don't care, Jesus comes from heaven and needs to ride to church. You get into a car and drive, we will have issues. Do you understand? Do you understand?
Yes, sir.
Do you understand?
Yes, sir.
Do you understand? Likewise, I'm ordering you not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or any illegal drugs, likewise, you will go to jail. No more PR bonds for you. Do you have a Texas driver license?
No, I haven't gotten it.
What's funny?
No, que siento culpa porque pude haber evitado muchas cosas.
No, I just feel guilty. I could have avoided many
Stop.
things.
I don't want you to say anything. You're in enough trouble as it is right now. Don't make things worse for you. The only 3 things I'm asking for you: don't drink, don't use illegal drugs, don't drive, and stay out of trouble. As long as you can do that, gentlemen, you and I will be fine. If I find that you're a danger to my public, I will put you over my knee, treat you like a child, and spank you like a child, but I will do it with a ton of jail time. Do you understand?
Okay, sir.
All right. We're going to reset each of your cases to give you time to hire a lawyer. So what's going to happen now, gentlemen? I will have you come up here. Each of you will sign a document promising me that you're not going to
Interesting.
drive.
No,
After
no,
that, I
no
will get you
story
to
here.
Ramona, where each of you will sign a reset. We're going to get you out of here for you guys to go hire a lawyer. After that, you will each get with Felicia for your bond conditions, so you sign and so you know exactly what you can and cannot do. After that, you will be free to go. Gentlemen, you are lucky that you're not in custody now. Make the most of it, because the next time you go to jail, you may not get as lucky. And I'm telling you, on any given day, I have about 10 people that are sitting in there with immigration detainers. Don't push your luck. All right.
Thank you, sir.
I'm outstandingly smart. That's how I get my jobs. And apparently I don't lie.
Okay, raise your right hand.
Happy Friday, Judge. How are you?
Good morning, Mr. Lambert. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 1st, 2024, the officer conducted a traffic stop on the defendant's vehicle after observing it operating with an expired registration traveling north on Kirby Drive. Upon contact with the defendant, the officer observed the odor of alcoholic beverage, glossy eyes, and an open container on the passenger side door.
An open container.
The passenger side door, Judge. Standard field sobriety tests were performed. HGN 4 out of 6, walk and turn 3 out of 8, one leg stand 3 out of 4. The DIC was read, but the defendant refused. Blood search warrant was signed and executed.
Stop for.
Expired registration, Your Honor. No driving facts, Judge.
What do you mean?
It's not like he ran a red light or failing a tendency to land. It was simply the registration.
Get it? He's got an open container. A year and a half ago, he had one dismissed.
I understand, Judge.
Do you have any more details? Is it cold to the touch? Is it halfway down?
Passenger side door.
I know, but people can put it in the passenger side door, Marcos,
Kind
you
of
know?
far. No, Your Honor, the only details we have are in the passenger side door.
You don't have any more information? I mean,
Information about the container, Your Honor.
And we don't have the offense report yet, Judge.
Correct.
We just want, that the DIMS don't clarify whether it's cold to the touch or warm to the touch.
how long? Because if I find that it's an open container, I'm taking away his privilege to drive. And I'd like to know because.
What is it?
Okay, yeah.
Raven, did
Yeah,
you
yeah,
leave
absolutely.
us?
Mr. Lemberg, I'm gonna find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm also now putting a prohibition on your license. You're not allowed to drive any vehicle that doesn't have an ignition interlock on it. If I catch you driving without an interlock, I'm gonna put you in jail. Do you understand?
Understood.
You will not get any more PR bonds. If I find that you have an open container of alcohol in the car while you're driving, I'm going to take your privilege to drive away from you. You're not allowed to drive for any reason. I don't care. Do you understand? So likewise, if I find that you drive, you will go to jail, and I can have a contempt hearing because I'm going to have you sign an affidavit with me today promising me you're not going to drive. I don't care if there's a burning building in 50.
Yeah, see, I'm in love with all of his metaphors. I'm in love with all of them. There's not any that I would get rid of.
Kittens that need to be saved. You drive, I can have a contempt hearing. You can be facing up to 6 months in jail and or a $500 fine every time you drive. Do you understand?
Sure.
I don't know yet, Marcus. If he's got the open container, it's going to happen. If it doesn't,
Judge,
then I'm
again,
not.
SUV, it's an open container on the passenger side door. And I'd have to look at all the facts of the case, Judge, and talk to my client, but, I've never seen a case where the open container is on the passenger side door. It seems to me.
If there was possibly someone else there, I
Of course,
get it.
that's exactly.
But, a little ingenuity goes a long way, as they say. You know what I mean? I don't know. I mean, perhaps he didn't see the furtive movements. Perhaps, I don't know. It was late at night. What time was this?
Your Honor, this took place at midnight, Your Honor.
I don't know. Let's see what they say, and then we'll go from there. For now, I'm gonna have you come up here, swear to this for now, and then I'll destroy it if they don't say that it's an open container. I'm gonna have you sign a receipt with Ramona. We'll get you with Felicia for bond conditions. You have a lawyer. I will waive your appearance while you have the lawyer, but it is your responsibility to stay in touch with Marcos. If he tells me he can't get a hold of you because you're playing games, then I'm gonna revoke your bond. You pick up a new case, you consume alcohol, endanger my public in any way, it's over. Say it again.
The deputy didn't answer the judge.
So just to be clear, Judge, is he able to drive with the interlock, or you're saying he cannot drive?
I guess I'll give him the benefit of the doubt now because I just don't know. But can you reach out to the officer? And then if you find that it is an open container, it's like cold to the touch, halfway, drunk, come back, let me know, and then I'm taking it away. For now, I'm ordering you not to drive any vehicle that doesn't have an interlock on it. And that's it. I would hope that it's elementary that you understand you're not supposed to have alcohol in the car while you're driving. Elementary.
Thank you, Judge.
Judge, do you want the order file?
Please.
Are you ready for this? When they have the license, it's easier for me because they.
7 days?
Yeah. Oh, Counsel, who's your client?
Bianca Fisher.
Okay.
Page 6, Your Honor.
Yes, sir, please.
Ms. Fisher.
Cheater. I bet you don't pay all your taxes too.
Good morning, Ms. Fisher. Ma'am, you were charged with driving while intoxicated. Is elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
I'm short. I'm a short person. So, but whenever I see a shorter defendant come up, I just feel like, boy, this is going to be spunky. This is going to be spunky. I don't know why. It's probably not going to be spunky. It just goes through my head. Oh, yeah, this one's going to be good.
Yes, Judge. On December 1st, 2024, officers conducted a traffic stop on the defendant's vehicle at approximately 12:01 a.m. after observing it nearly rear end a parked vehicle on Alameda Road and failed to maintain a single lane by driving over a solid yellow line. Upon contact with the vehicle, the officer observed the defendant to be the driver and sole occupant and observed the defendant to have strong odor of an alcoholic beverage, slurred speech, and bloodshot eyes. The defendant admitted to drinking, and upon stepping out of the vehicle, the officer observed the defendant to be staggering while walking and to have poor balance. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The DIC was read and the defendant consented to breath. The results were 0.249 and 0.229.
249.
Yes, Judge.
Any prior to the guys?
No, Your Honor.
Okay. Ms. Fisher, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I don't know if you have a problem with alcohol. If you do, you better address it, because if you don't and it becomes a problem, I'm going to address it for you, and I promise you're not going to like the way that I do it. Do you understand? And no alcohol from any source. Do you have a Texas driver license? Do you have liability insurance in your name?
Full coverage.
Okay, you can continue to drive, but just be careful. If you lose insurance, lose a license, you're not allowed to drive. For what it's worth, no alcohol, no illegal drugs. You have a lawyer, I will waive your appearance, so you don't have to waste your time coming to court, but stay in touch with counsel and he'll tell you when you have to come back to court. If he tells me he can't get a hold of you because you're ducking and dodging, I will issue a warrant for your arrest, okay? All right. I'll have you sign a receipt with Ramona. We'll get with Felicia for your bond conditions, then you're free to go. All right, thanks, guys. Trevor, I saw that Paul had a case on. You guys still dancing together or what? You guys still dancing together? Come on, you ready? Yeah, come on. Yeah, come on.
He's here on Jose Castillo on
Yeah.
page 2, Your Honor.
Come up, please.
Castillo? Sorry. No. Come on, switch over here.
Ramona, if we go too fast, just tell me and we'll slow down. You are Jose Castillo. Mr. Castillo, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. While patrolling, the officer observed the defendant's vehicle nearly strike his own vehicle and failed to maintain a single lane despite other vehicles within the vicinity of the defendant's vehicle.
Wow, Jen is here. Hi, Jen. Guys, you got to check out Jen's channel. Hold on, I'm going to send you the link right now.
Pull up my channel on my computer
There
so
she
that I can.
is. I know most of you have already been. I know that most of you have already been. But if you haven't, you have to check out Jen's channel. It's awesome. She does the best interviews ever. And she is a bestseller. She wrote, she did like a how to do YouTube videos, and it was a #1 bestseller. It still is? Is it still #1?
The officer initiated a traffic stop and observed a moderate odor of an alcoholic beverage, slurred speech, and glossy eyes. The defendant admitted to drinking at a party. Standard field sobriety tests were then conducted. HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 4 out of 4. The DIC was read and the defendant initially consented, but then withdrew consent. A blood search warrant was signed and executed.
Any prior DWI?
No, Your Honor.
Okay. Mr. Castillo, do you have a Texas driver license?
Yes, sir.
You're not allowed to drive. Do you understand me?
Yes, sir.
You will be signing an affidavit with me today promising that you're not going to drive. I don't give a rat's behind what your excuse is. If I find you drive, I can. We'll have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time your happy ass gets into a car. Do you understand?
Yes, sir.
If you want to drive, go get a license, get liability insurance. But until that point,
I apologize. He had a license. He said, yes, sir.
I say yes, sir.
but you have a license.
Yeah, I say yes, sir.
You said you didn't have a
He
license.
said, yes, sir.
I said.
I heard it the same way you did, but
He said he didn't.
No, I did. I
I
said
heard,
yes, sir.
yes, sir.
Can you run his license?
It's eligible, Your Honor.
Great. Okay, you can drive.
I-
I heard no.
I heard yes.
For what? Don't drink. Don't use any dope.
Yes, sir.
Don't drink alcohol. Don't use illegal drugs. As long as you don't, you and I will be best friends. Don't pick up any new cases. I'm not asking much from you. You've got great counsel. Listen to them. They'll take care of you. As long as you don't pick up a new case, you don't drink, don't use illegal drugs, we'll be fine. All right?
Sir.
Maintain that license. If you lose that license because of one reason or the other, you can't drive, and they'll, tell you about it. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but stay in touch with them and they'll tell you when you have to come back to court. All right?
Sir.
Just to confirm, you can drive?
Yeah, just no drugs, no alcohol, anyways. So I'll have you sign a reset with Ramona. We'll have you get with Felicia for your bond conditions, then you're free to go. All right?
Thank you, Judge.
Sorry for the scare.
Have a good day.
Good morning, Ms. Flores. Ma'am, you were charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes, Judge. Officers were dispatched to a residence in Harris County, Texas, in response to a family disturbance. The reportee stated that her brother assaulted her father, and the officer went upstairs to make contact with the brother. The officer could hear yelling inside the bedroom and instructed the brother to come out. The brother opened the door but refused to come out of the bedroom and then closed the door on the officer. The officer entered the bedroom when the defendant, the brother's wife, stepped in between the officer and the brother. The officer attempted to detain the brother for the assault investigation, but the defendant continued to step in between the two.
All right, ma'am, I'm going to find that there's probable cause to go forward with your case. I'm not going to put any conditions on your bond. Just be careful. It's when you get into a pissing match with people with authority to arrest, who's going to win? Right. Just be careful. What do you do? How old are you, ma'am?
30.
What do you do with yourself these days?
I'm a teacher. I'm a teacher. I work.
At an elementary school or?
Goddard.
If you have the opportunity to sleep, go to sleep, guys.
Goddard School of Katie.
Would you like to apply for an appointed lawyer, ma'am?
Yes.
Okay. Stephen, I'm going to give you an application for an appointed lawyer. I'm going to have you sign a reset with Ramona. We'll have you take a seat while we just wait and try to find you a lawyer. Okay?
100%.
Please.
Yep.
Say it again?
Go ahead and reach out.
No, read out, yeah, yeah. Good morning, Ms. Funes. Ma'am, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. Officers were dispatched to a residence in Harris County, Texas, in response to an assault. The complainant, the defendant's mother, told the officer she was driving the defendant to work when the two began to argue about the complainant's driving. The defendant then grabbed the complainant's hair and began hitting her in the head and chest, causing pain. The officers
While driving?
While driving, yes, Judge. And the officers observed a red mark on the complainant's face.
You know if mom wants to have contact? Ms. Funes, I'm going to find that there's probable cause to go forward with your case. I typically don't allow contact when we have this kind of situation where someone has picked up an assault against another person.
Your Honor, RIP has not been performed yet.
Okay. It appears that a protective order has been issued in this case. I would get to know it, because if you do something to violate the protective order, like go to the house listed in the protective order, have contact with someone listed in the protective order, the state can and will file a violation of a protective order against you. That is the capital murder of misdemeanors. It's one of the worst cases you can pick up, so you must be very careful. Until I know that she wants to have contact with you, I'm ordering you not to have contact with her. Do you understand? I'm also ordering you not to be in possession of weapons as well. Do you work, ma'am? What do you do? What kind of money do you make a month? Do you have the ability to hire a lawyer? I'll have you fill out an application. I need you to be honest. Please don't just put zeros. I'm going to send it right back to you. I need to know everything about you, how much money you have coming in, what kind of car you drive, if you own a house, property, stocks, bonds, mutual funds, what expenses you have. Let me take
Brent clearly offered.
a look at it and I'll see whether you qualify. Okay? Do not leave until you sign our bond conditions though. All right?
I'd like to ask for permission to go pick up my belongings. Everything I have, everything I own is in that house.
Let's do this. Let me have you fill out the application, see whether you qualify for a lawyer. If you do, we'll have you talk with a lawyer and we'll work something out. Okay? Please. We'll come back to you and we'll work something out. Please.
All right, guys. That's it. We made it to the end. We got our daily dose of Judge Fleischer. And we got an attorney who is misbehaving badly. Badly. And I'm glad we did that one instead of the one I had queued up. Actually, now that I'm thinking about it. The other one didn't misbehave as an attorney. He, apparently what he says, this is what he says. His stepson, who is a full-grown adult, his stepchild, is not a child. He's an adult. Had some mental health issues going on and attacked him, and he shot him, and he passed away. So they disbarred him, or they were going to disbar him because he committed this. He pled guilty to aggravated assault. So he said it was self-defense. If I was an attorney and it was self-defense, I would never plead to aggravated assault, right? But he did. So because he had that charge, the guilty plea, he didn't plead no contest, he pled guilty. They wanted to disbar him, and he said, no, you can't disbar me because, that was just a bad night. I was being attacked, blah, blah, blah. So it only just happened, so we don't have a verdict yet. But it doesn't matter because I didn't play it. I have a members only that I want to do, but I got to work another double today. So I actually can't even do I can't even do the OJ today because I have to be at work in like 2 hours. So I'm going to go to sleep. But OJ is coming tomorrow. Absolutely going to do OJ tomorrow. So, yeah, lawyers should know things. Yes, I could hear it crystal clear with no problems. But I can record those and then spin them through my sound thingy do. Were you timed out, Donald? Yep, that sewed it. That just sewed it. Okay. Guys, be good. Be good. Love you. Love you. Thank you for coming out. I shall see you soon. Very soon.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales waiting to the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Her eyes mirror sky so blue. In her jokes there's a truth so true. With each stream she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Kathy's